Now let's move on to campaign ethics. By a show of hands, which of the school board members were elected to be in this position?
You're not here.
Okay. Tyrell.
Why?
Okay. Okay. Well, regardless, we will discuss campaign ethics here because it's important for us to all know what's prohibited under the code. Um, so under the city's code of ethics, the prohibited conduct of political activities while you're in duty is for one, you cannot take part in any political management or campaigns during duty hours, during uh, school board hours, or during the time that you dedicate to the school board. You cannot solicit contributions from employees of the city or municipal agency during the employee's hours of employment. And you cannot solicit or knowingly accept any campaign contribution in any city facility. There are further considerations here that are prohibited. For example, the use of city time, which was already discussed, the use of city property, which is any equipment or supplies, any social media pages for political campaign activities needs to be separate from your, if you're posting something about the school board. Do not sell, buy, or pass out campaign fundraiser tickets on city time and in city facilities. It's prohibited to use your title or position to pressure others into making campaign contributions that should be very obvious, or to assist in any campaign tasks or activities during city hours. It's prohibited to allow candidates walkthroughs in non-public areas of the city, province, or city buildings that are not public areas. And it's prohibited to subscribe to campaign distribution lists using your city email account. Anything that is not city business should not be going through your city email account anyways. You have to keep everything separate, including any personal matters that you're emailing. Keep your personal matters and your city matters out separate. And I'll discuss why in a little bit under the APRA. Are there any questions so far about campaign activities? Okay. We're moving on to the revolving door prohibition. So as city officials, there are legal obligations that you have to comply with even after you leave city service. So after you leave city service, you cannot accept or seek employment with the city of Providence for 1 year after leaving, except for positions that you have held before your election or appointment. There are some exceptions. It's very fact-based, but the exception would only be given if there's a substantial hardship to the reason why you would have to, if there's a substantial hardship for the body or the board, then the Rhode Island Ethics Commission may give approval for a particular appointment. Another obligation that you have is to file financial disclosures every year. They are due on the last Friday of April, and these are filed with the Rhode Island Ethics Commission. Usually they will mail you a reminder. The form is found online. You can do it electronically or by mail. And you have to continue filing for 1 full year after you leave city service if you, once you leave, once you're no longer a school board member. Any questions so far? Okay. So we're moving on to the Access to Public Records Act, and we're almost done. Who is familiar with the APRA? Okay, the Access to Public Records Act, also known as the APRA, is a state law that gives individuals, gives the public the right to see and obtain any public records. Now, that list is very broad of what what consists of a public record, it's very broad, and the law provides guidelines for obtaining access to these records and which records are subject to inspection and which should remain private or should be withheld. There's 27 exemptions under the law, and exemptions include personal privacy, attorney-client privilege, trade secrets. And you, as school board members, are subject to the APRA. So this is a list of the documents that are, or records that are considered to be a public record. As you can see, it's very broad. It includes documents, papers, letters, maps, and it goes on, photographs. This also includes your emails as city officials. As city officials, anything that you produce in relation to the city is considered a public record. That is regardless of whether it's on your personal cell phone or your personal computer. That's why it's important for you to keep everything separate. If you are responding to a text message, if there's a text message thread on your personal cell phone, a member of the public can still request for that message to, they can still seek and obtain that message because it relates to city business and your official business. Therefore, you should think twice before sending any emails. And of course, student records are confidential. They're confidential under both the Rhode Island Educational Bill of Rights and the Family Educational Private and Privacy Rights Act. School records can only be released pursuant to an authorization form from the student's parents, guardian, or caretaker, or a court order compelling the school department to release the records. Okay, the Open Meetings Act. This is our last topic for the day. So the Open Meetings Act requires public meetings to be open to the public. It ensures that public business is conducted in an open and transparent manner, allowing citizens to participate in their government. When does this law apply? It applies whenever a quorum of a public body convenes for a meeting. All three elements must be met. There must be a public body, there must be a meeting, and then a quorum, which is a simple majority of the memberships of a public body. Now, something that I'm going to go out of order here. So I don't have a slide for this, but I'm just going to let you know that when you reply all to an email chain, that may run the risk of violating the Open Meetings Act if there's a quorum that is formed. Not only with emails, this includes any group chats, any chats on WhatsApp, any conversations, anything that is being discussed. If it's better for you not to do it, okay? Because whenever there is a quorum discussing any city business and you are not in a public meeting, then it violates the Open Meetings Act.
Can I ask a question, Rosa?
Yes.
So, what about, for tonight, for example, we're trying to figure out who's actually going to show up to this first meeting, which is entirely important in an obligation and, in my mind, a duty to the folks who were voted in and those who've been appointed. And so today we're trying to figure out who's coming to the meeting. You know what I mean? Like, who's even showing up? What do we need to do? I'll say for me, am I allowed as a board member to ask somebody in a group chat or an email thread, hey, are you guys showing up to a meeting? Or is that like a violation? Or like, is it like a discussion of a topic? Do you know what I mean? Like, is there a difference in any of that?
There is a difference,
Okay.
because you are conversing first, before I answer that. It's better to just not engage, Okay, it's better to just, it's best practice to not have those chats because it's too risky. To answer questions, because the conversation was about who will be present at the meeting, it's not necessarily about something that is on the agenda for tonight's meeting, then that should be okay, but it still runs a risk. Charlie, would you like to add something?
I think that's right. If you're simply trying to get a sense of who is going to be in attendance, you're not speaking about a matter in which you have supervision, control, or jurisdiction over necessarily. I think you do potentially start to open the door to a conversation, especially in a group chat where you don't know what the response is going to be from someone else who may start to talk about a topic that's on the agenda for discussion or action. And once you start talking about a topic that's on the agenda for discussion or action, now you're encroaching upon that area in which you have control, supervision, or advisory authority over. So that's the risk. The risk is that you extend the conversation beyond that. That's why I think ideally you'll have someone like Martha see, she'll contact you, she'll contact Nightshade, and everyone go through the list and understand who is actually going to be present before the board meeting, rather than potentially putting any board member in that position.
Thank you.
And, yes,
I have a question about rolling calls.
yes.
Okay. Yeah,
That
because I
is-
know you said if you reply all, it's against it, but if we do individual, is it not the same?
Yes, so it's a walking or a rolling quorum may be created when a majority of the members attain a quorum by a series of one-on-one conversations or interactions. So with the text messaging example, that can turn into a rolling quorum. It doesn't have to necessarily be in-person interaction. It can be by electronic means, even an email thread.
Thank you.
Can I ask one more follow-up? Is my mic on? Okay. So, in the event that board members are texting or talking about not coming to a meeting in mass, is that a rolling quorum if that wasn't discussed in public or in a group chat? Like, would that be considered a rolling quorum if people's agreed to not show up tonight for a meeting?
Like agreed.
Actually agreed to
Not be.
to stop business? I'm sorry, Rosa, I don't want to.
No, it's okay. I am glad that you're raising this. I am glad that you're raising this question. It's very important. I think when it comes to, that's why I said don't engage. Because if you don't engage, then it's one less person in that conversation. And if everyone follows the law and abides by the law, then there will be no conversations that are not in public. But when it comes to scheduling, I want you to look at prong number 2, where it says something that the school board has supervision, control, jurisdiction, or advisory powers. So those are matters, usually matters that come before you. Give me a good example. What's an example of
Certain contracts, you could have a contract.
a contract? So if you're discussing the an RFP, a request for proposal, or a bid, if you're discussing the contract itself or any requirements that needs to be met in order to be granted the contract, then that is something that you have control, supervision, jurisdiction, or advisory power over. This also includes workshops, working sessions, and work sessions, which if you have, if you have questions, I'm available by phone. Because I think it's hard to control what others do. And when there's a group chat and people are actively agreeing not to attend the meeting, these are your fellow board members. You are city leaders. You are city officials. But it's hard to influence someone's conduct, you know.
I also had a question, which was about, if we're gonna try to, if for example, we wanted to put an action item on the agenda for the next meeting, right? Would you typically need to introduce a motion to add an item to the agenda for the following meeting? Is that how that's normally done? Because I know the agenda is typically set by, once somebody's elected president, whoever's president sets the agenda. If I, as a board member, want us to have a discussion about something, want to add an item to the agenda, would I just contact the president? But if the president doesn't, there might be something the president might not want to put on the agenda that I think we need to discuss. If that's the case, would I have to do that as a motion in a previous meeting in order to avoid that?
Okay, so agendas are usually posted 48 hours in advance in order to give the public enough notice of the meeting and what's being discussed. If there is an item on the agenda that is added at that meeting, that's not enough notice to the public. Therefore, if something relating to that matter is up for discussion in the agenda, you may discuss it, but not add a new item onto the agenda.
Right, no, what I'm saying is, say I have a question that I think the board needs to discuss, would I need to add it, say if this meeting, if we had picked a president, would I need to introduce the motion at this meeting to have it added to the agenda for the following month?
I can help this if you like.
Yeah.
So Steve, I think, first, if the topic has to be something that's been properly noticed, which Rosa was just stating. So if you're talking about something that's been properly noticed and you're discussing it in the course of a board meeting, you can certainly say that at the next board meeting, I would like to have this item back on the agenda with a motion to do X, and ask the board entertain that or ask to have it put on the agenda. Alternatively, you could ask the president directly to put the item on the agenda as he's making the agenda for the administration for the succeeding meeting. But to your point, you can talk about it if it's a topic of discussion that's already been properly noticed. And during the course of that discussion, if you would like to have a motion on it, you can either potentially make a motion depending upon how that item is noticed on the agenda at that very meeting, or you can ask that your motion be entertained at the next meeting.
So I guess my question was really about something that has not appeared on the agenda. Could I just introduce a motion saying, I don't want to discuss it at our current meeting. I just want to put this item on the agenda for next month or 2 months from now. I think we need to look at this issue in the future, and I would like to add an agenda item at a future meeting.
And I think the question is, how do you get into the discussion? Right? So if there's been a proper notice on the agenda that affords you the opportunity to have this item generally up for discussion, and you specifically wanted the next meeting a motion that's related to that.
Okay,
you can
so
make that request.
if that's the case, then we can never introduce any topic for discussion until the president has agreed that it should be introduced for discussion. Like if we can't even discuss the possibility of discussing something in the future, like I can't even say, I don't know, I think we need to look at the new way that school crossings are painted. And the board has never discussed that. And the president says, no, I don't think it's a serious issue. Then I just basically have to say, it's just never going to appear on the agenda, because it has to appear on the agenda to even make a motion to put it on the agenda.
I would recommend having an item on the agenda that opens up the possibility of future discussions on items that are not related. So maybe like the last item on the agenda can be
We have a school board comment section of the agenda. During the portion of those school board comments, part of your comments may be attributed to this item, which you would like to further explore in another meeting with a possible motion. So those school board comments, I think, can more generally grasp the topic of conversation that you're alluding to.
Yes, and if there's something that is discussed during the school board meeting that relates to something on the agenda, then there's no problem with that. Okay. Let's discuss executive sessions. So under the law, there has to be specific language in order to go into executive sessions. And there are certain specific topics that should be in executive sessions. For example, job performance, collective bargaining or litigation, student disciplinary hearings, those topics, or any civil or criminal misconduct investigation, those topics would be discussed in executive session. And the explanation or the reason for executive session must be held publicly on the agenda, published 48 hours in advance. And it should read like this example here, where it says, where it provides the reason. It says to discuss the pending litigation of this case. It's very specific as to what is going to be discussed in executive session. And that's stated on the agenda. Now, when you're in executive session, any votes that are taken in that session must be disclosed to the public once you reconvene in an open meeting. There is an exception. For example, if it'll jeopardize any strategy or negotiations or investigations, that's different. Those matters must be kept confidential. However, anything else, any votes, any city business would have to be disclosed to the public once you reconvene.
Are there a certain amount of executive sessions we can have, like in a year or something?
There's no limitation.
That's a good question. No limitation. Thank you, Charlie. Now, here are some further things to consider about, well, this, I already discussed this. That concludes my presentation. There was a duplicate slide in there. Are there any additional questions or anything that is still left a little fuzzy or unclear? No? If there, yes.
Because it's the code of ethics, I guess I have a question around like our duty as a board. Like I feel like when we violate our duty of the board, what we were elected or appointed for, that feels like a violation of ethics. Is this a different type of ethics?
So, thank you for your question. Something that I didn't discuss in my presentation is the advisory opinions. So the Rhode Island Ethics Commission can issue formal advisory opinions on any matters where there may be a conflict of interest or any matters in which you have questions or concerns. That is a public process. With me, you can come to me confidentially and receive informal advice, which would not be binding. But if it really, it depends on, it depends.
That's fine.
It
I'm
depends
sorry.
because under the code of ethics, we'd have to look at whether there is a section that is actually being violated.
Okay. Thank you.
Charlie,
I was just gonna comment on one thing. I think many times these inquiries and the issues are pretty fact intensive. So I think it is helpful, to just make sure you have Rose's contact information and Leonella's contact information. If there is a conflict, if there's some other issue that you think potentially poses an ethical issue for you or for the board generally, I think it's a good thing to just reach out rather than to try and wait till the board meeting to try and navigate it. Because they are frequently fact intensive. The facts matter.
well, that concludes my presentation. Thank you again for having me.
Thank you.
So there's no need to have a motion to adjourn. This is the only item that we have that was a work session item. So there's no other business to come. Thank you, Rose.
Thank you very much.
Thank you.
Thank you so much. I'm sorry, everyone. was disappointed, and I'm sorry.
Yeah, and if you have questions, we'll let you know what we know.
Yeah.
I'll let you, I'll speak for me, I'll let you know what I know, so feel free to come up to me after this meeting.
Same.
Hey,